Good evening, everyone. We're going to stick with the Emer de Vattel and the legal word format for this go around as well. Now, because a lot of what Vattel put out in the Law of Nations can be used to tie much of the different government types together, as well as show how any government type could or can be truly of the people. It can also be used to show why virtually all government types fail to be of the people. But put in its simplest words, most fail to be of by the people because the people fail to keep hold of their government by means of the deception used by their elected representatives. In other words, we the people trust too easily our elected representatives. Let's start with Vattel again. But this Constitution is a vain phantom, and the best laws are useless if they be not religiously observed. The nation ought then to watch attentively in order to render them equally respected by those who govern and by the people destined to obey. It is very uncommon to see the laws and constitution of a state openly and boldly opposed. It is against silent and gradual attacks that a nation ought to be particularly on its guard. It would be rendering nations an important service to shew them from history how many states have thus entirely changed their nature and lost their original constitution. If any nation is dissatisfied with the public administration, it may apply the necessary remedies and reform the government. None but the body, the sovereign people, not a few malcontents of a nation have the right to check those at the helm when they abuse their power. But it is asked what is to be done if the people are divided. In the ordinary management of the state, the opinion of the majority must pass without dispute for that of the whole nation. But if the question be to quit a form of government, note, now this is my opinion, much of what is said is in its simplistic meaning that those who disagree, the minority, with the forming of a new government, are under no obligation at all to submit to a new government. They may quit a society which seems to have dissolved itself in order to unite again under another form. They have the right to retire elsewhere, to sell their lands, property, and take with them all their effects. Now from Black's Law, administer, to manage or conduct, to discharge the duties of an office, to take charge of business, to manage affairs, to serve in the conduct of affairs, in the application of things to their uses, to settle and distribute the estate of a decadent. More Vattel. The Constitution and the fundamental laws are the plan on which the nation has resolved to labor for the attainment of happiness. The execution is entrusted to the elected. Let them religiously follow this plan. Let them consider the fundamental laws as inviolable and sacred rules, and remember that the moment they deviate from them, their commands become unjust and are but a criminal abuse of the power with which they were entrusted. Note, some of the words are replaced with ones that match our type of government since we are not ruled by a king or a queen. And a note from Black's Law. Whenever they happen to violate the laws of the country, they, the people, shall be absolved from the oath of allegiance they have sworn until ample reparations be made for the outrages committed. Back to Black's Law. In public law, the administration of government means the practical management and direction of the executive department or of the public machinery or functions, or of the operations of the various organs of the sovereign, direction or oversight of any office, service, or employment. The term administration is also conventionally applied to the whole class of public functionaries, or those in charge of the management of the executive department. More Vattel. But the body of society does not always retain in its own hands the sovereign authority. It frequently entrusts it to a senate or to a single person. That senate or that person is then the sovereign. So refreshers on what senate and sovereign are. Senate in American law, the name of the upper chamber or less numerous branch of the Congress of the United States. Also the style of a similar body of the legislatures in several of the states. Sovereign, a person, body, or state in which independent and supreme authority is vested, a chief ruler with supreme power, a king or other ruler with limited power. It is evident that men form a political society and submit to laws solely for their own advantage and safety. The sovereign authority is then established only for the common good of all the citizens, and it would be absurd to think that it could change its nature on passing into the hands of a senate or monarch, single person, the representatives of a nation, that they have the glory of the state and the happiness of the people as their main views. Again, wording was changed to better represent the current types of governments. But in most kingdoms, nations, a criminal flattery has long since caused these maxims to be forgotten. More from Black's Law. Political, pertaining or relating to the policy or the administration of government, state, or nation, pertaining to or incidental to the exercise of the functions vested in those charged with the conduct of government, relating to the management of affairs of state, as political theories, of or pertaining to exercise of rights and privileges, or the influence by which individuals of a state seek to determine or control its public policy, having to do with organization, or action of individuals, parties, or interests that seek to control appointment or action of those who manage affairs of a state. Policy, the general principles by which a government is guided in its management of public affairs, or the legislature in its measures. This term, as applied to a law, ordinance, or rule of law, denotes its general purpose or tendency considered as directed to the welfare or prosperity of the state or community. Policy of a statute or legislature, as applied to a penal or prohibitive statute, means the intention of discouraging conduct of a mischievous tendency. Policy of law. By this phrase is understood the disposition of the law to discountenance certain classes of acts, transactions, or agreements, or to refuse them its sanction, because it considers them immoral, detrimental to the public welfare, subversive of good order, or otherwise contrary to the plan and purpose of civil regulations. Public policy, that principle of the law which holds that no subject can lawfully do that which has a tendency to be injurious to the public or against the public good. The principles under which the freedom of contract or private dealings is restricted by law for the good of the community. Policy as applied to a statute, regulation, rule of law, course of action, or the like, refers to its probable effect, tendency, or object, considered with reference to the social or political well-being of the state. Thus, certain classes of acts are said to be against public policy when the law refuses to enforce or recognize them on the ground that they have a mischievous tendency so as to be injurious to the interests of the state apart from illegality or immorality. Public policy is the community common sense and the common conscience extended and applied throughout the state to matters of public morals, public health, public safety, public welfare, and the like. It is that general and well settled public opinion relating to man's plain, palpable duty to his fellow men, having due regard to all the circumstances of each particular relation and situation, or derivable by clear implication from its constitution, statutes, and judicial decisions. Public policy is a variable quantity. It must and does vary with the habits, capacities, and opportunities of the public. Politis legibus non legis police adaptative. However you say that. Politics are to be adapted to the laws and not the laws to politics. Politics, the science of government, the art or practice of administering public affairs. Polity, the form of government, the civil constitution. Political offenses, as a designation of a class of crimes usually accepted from extradition treaties. This term denotes crimes which are incidental to and form a part of political disturbances, but it might also be understood to include offenses consisting in an attack upon the political order of things established in a country where committed, and even to include offenses committed to obtain any political objective. There is no definition for theories or theory to be found in Black's Law, so following is is theory as found in Merriam-Webster's. Theory, noun, a possible or scientifically acceptable general principle or body of principles offered to explain phenomena. A belief, policy, or procedure proposed or followed as the basis of action. An ideal or hypothetical set of facts, principles, or circumstances, often used in the phrase in theory. Hypothesis assumed for the sake of argument or investigation. An unproved assumption, a conjecture. A body of theorems presenting a concise, systematic view of a subject. The general or abstract principles of a body of fact, a science, or an art. Abstract thought, speculation. The analysis of a set of facts and their relation to one another. And this is what I did find in Black's Law. Theocracy, government of a state by the immediate direction of God, or by the assumed direction of a supposititious divinity, or the state thus governed. Theory of case, facts on which the right of action is claimed to exist, the basis of liabilities or grounds of defense. Okay, this is going to be a good place to stop for now. And as always, this is, again, just a small amount and leaves much for us to get into. And as always, we will little by little, just to help permit information overload or burnout. So if you have found this to be beneficial in any way, then please visit and like my YouTube and Rebel channels. As always, remember to share across all your social platforms, and most importantly, with family and friends in other countries, as this is a global war. Blessings and much gratitude to all of you.